after the trial has been concluded, the court will set a date for judgment. On that date, you will find out whether your application or your claim was successful or it was not successful. If you are successful, you succeed with costs. Costs are awarded because you had to litigate to enforce your rights, when you could have avoided it if the respondent or the defendant had paid you without making you work for it. If your case is dismissed with costs, you will have to pay the defendant for putting them through the trouble of defending a case that turned out to have no merit. This is why costs are ordered. This is why people have to avoid litigation by all means. If somebody claims money, if somebody demands what's due to them, come to an understanding, make a payment plan, make an arrangement out of court in order to pay them, and stick to that payment plan. Try by all means to liquidate your debt. Try by all means to meet them halfway, or to fulfill your obligation to them. So assuming you were successful in your application or your lawsuit, you were granted a judgment in your favor. If it's a judgment that results in payment, or judgment that grants you an order for payment, you then have to demand that the defendant pays you within a specific time. If they fail to pay, enter the deputy sheriff. You now have to apply for a writ of attachment of property, because the defendant refuses to voluntarily pay you the money that's due to you. So the next step is to apply to the court for a writ. A writ is a document that allows you to attach movable assets. You apply for a writ of attachment of movables. Once you get the writ, you engage a deputy sheriff who is authorized by law to enter into somebody's premises, to attach goods, to attach property, to make an inventory, and even sell it, advertise it and sell it, so that you can recover your debt. If the deputy sheriff cannot find anything valuable or anything that can be attached or salvaged in order to help you recover your debt, they will issue a report. That report will indicate that there's nothing to attach. It doesn't necessarily mean that the house is empty. It just means the couches are too dilapidated and it would be a waste of time to even try and attach that. So it's an assessment. So when he says there's nothing to attach, it means there's nothing valuable that he can attach in the hopes of helping you recover your money. Once you have that report, you have two options afterwards. If your defendant is gainfully employed in a stable job that pays consistently in a parastatal or a government entity especially, you can apply for a garnishee order. That is to say, for a stop order, deduction from their salary on a monthly basis. You can apply for a stop order, which allows you to get paid the same way that a bank would get paid through somebody's salary. Constant payment, a constant deduction of payment from their salary. Alternatively, you can apply for civil imprisonment. That is to say, the defendant has refused to pay and they have no assets that I can attach. And then you apply that a warrant of arrest be issued for that civil debtor. Once the warrant has been issued, engage the deputy sheriff again. This is where they come in, so that they might arrest and detain the defendant for a specific period of time during which time you want to believe they will come to their senses, they will start to prioritize your payment as they do with all other payments. It could be 30 days, it could be 60, some go as far as 90 days. That is something that you choose civil imprisonment with the hopes that the defendant is responsible enough to understand the implications of having a civil imprisonment order issued against them. Some of them work, they have to get to work every day. So if they are arrested today, it means they are not going to be turning up for work and they are likely to be dismissed from work. So it's a priority issue. It's an issue where you are compelling the defendant to prioritize your debt because you're holding a court order that could deprive them of their freedom of movement for a significant period of time. Okay, so in short, the purpose of this video was to try and highlight why it's expensive to litigate. Money is paid from stage one throughout the trial. It doesn't end with judgment. There's the enforcement stage where you must make sure your judgment is obeyed. When you engage a deputy sheriff, he must be paid. Every step that follows after judgment requires that you part with money to engage people who can assist you with doing your work. You cannot attach goods personally. They must be attached by someone empowered by the court to do so. So we circle back to why litigation is expensive. It's both for the evidence and it's also expensive because enforcement of judgments is expensive. You cannot do it alone. You need to engage specialists, individuals who have the authority to go to places that you cannot go on your behalf. Can't be avoided. So if you are ever invited for case management conferences to meet and discuss a settlement, you lose nothing by attending the meetings. Have a sit down, hear what they have to say, find out if the offer is worth it, and weigh the cost of litigating against the cost of settling your dispute. Let's chat again next time. Thank you for tuning in.